Good morning, Your Honors. May it please the Court, Joseph Pieropan, Assistant District Attorney for the Commonwealth. It is quite simply the Commonwealth's position here that the juvenile court judge erred by removing the verdict of delinquent from the docket sheet in continuing the juvenile's case without a finding after the jury trial. The Commonwealth is mindful and very cognizant of the clear language of Section 58 of Chapter 119 that at first reading would appear to provide a trial judge with the authority to do that. That is to say, to continue a matter without a finding after a jury has entered a delinquency finding on the verdict slip. The Commonwealth's position, with all due respect to this Court, is that when examined in the context of the entirety of not only Chapter 119, but also the balance of the general laws of the Commonwealth and of the common law as well, that is not a permissible sentence under law.
I was confused, and it may be that I just didn't bear down enough. Are you arguing that the language in Section 58, first paragraph, only applies to a pretrial resolution?
Correct, Your Honor.
And the whole section deals with pretrial resolution?
No. It's the Commonwealth's position that Section 58, which appears quite nicely in the juvenile's brief at page A6 and A7, is divided into several different paragraphs. It was amended to reflect the youthful offender provisions that came into existence in the mid-1990s. However, the Commonwealth's position is that because the use of the word hearing in the very first sentence of the very first paragraph of that section limits the consideration of that application, rather, of that paragraph.
But the second sentence of that paragraph is talking about allegations are proved beyond a reasonable doubt. I don't know of any pretrial motion in which there's a burden of proving beyond a reasonable doubt.
No, pretrial plea, Your Honor.
But it also says if the court hears the testimony, which is unlike a plea.
Well, Your Honor, unfortunately, I disagree because I've actually, in the course of pleas, been sworn under oath by the court to give testimony. And I understand it's not a common occurrence, but I can also tell the court that I've had pleas rejected because the Commonwealth's evidence didn't amount to proof beyond a reasonable doubt. So I would submit that although the juvenile relies upon the plea form to somehow excuse the Commonwealth from proving its case beyond a reasonable doubt in a plea, that's simply not the case. The plea form simply advises the juvenile that he or she is waiving their rights to a jury trial, to confront witnesses, to present evidence on their behalf.
Are you suggesting that when a judge takes the plea, that the judge is making a specific finding that the Commonwealth has proved its case beyond a reasonable doubt?
Absolutely. I don't see why that's incredulous. The Commonwealth must prove all its cases beyond a reasonable doubt. At a plea or a submission, the defendant, by waiving their right to remain silent, they actually agree with the Commonwealth that on those facts, yes, the court may find beyond a reasonable doubt the matter has been proven to the satisfaction of a conviction, or in this case, an adjudication of delinquency. I do not think the Commonwealth is ever excused from proving anything when it comes to adjudications or findings of guilt or innocence beyond a reasonable doubt. In fact, even during hearings on the voluntariness of confessions, the Commonwealth bears the burden of proof beyond a reasonable doubt. So in that sense, Your Honor, I think that the drafting of the statute is quite odd. I think it's ill-placed. And I think this Court could, in its wisdom, find that certainly when a jury has heard all the evidence at a formal trial and has rendered a verdict of which it be given a verdict slip that says delinquent or not delinquent, then the trial court goes beyond its authority to remove that verdict that has been entered by the jury.
When a jury makes a finding of delinquency, is that an adjudication of delinquency?
It is an adjudication, Your Honor, yes.
All right. So, and you're not basing it on that. You're basing it on the first paragraph, or are you basing it on both?
Well, on the first paragraph.
All right. Now, going back to the first paragraph, if it were to be a bench trial and the judge were to hear all the evidence, why could a judge say, I'm not going to make a finding of delinquency, but on this evidence, I'm going to find beyond, I'm going to say that there is evidence supporting proof beyond a reasonable doubt, but I'm going to do a continuance without a finding. I'm not going to make a finding.
I would say
why is that outside the language of the first paragraph?
Well, I would say that because the Norrell case from 1996, albeit in the adult context, specifically prohibits a judge at a bench trial, after trial, to enter in a continuation without finding. I would say furthermore that that is consistent with the interpretation of the first paragraph of Section 58 to apply to submissions or pleas, not to trials, bench or bench waived.
Right,
Or
but I'm
jury
focusing on the
waived.
second paragraph, which speaks about the adjudication of a delinquent child.
Correct.
Now, if in my scenario there's been no adjudication of the child as delinquent, the judge has not made that adjudication, which would differ from a jury which has made the adjudication.
Well, I guess we're of a different mind here, but the Commonwealth is arguing that after a bench trial, the court is prohibited from continuing the case without a finding. The court must either make an adjudication of delinquent or find the juvenile not delinquent. If the juvenile is found delinquent pursuant to Section 2, or paragraph 2 rather, Your Honor, then the option is you can place the child on probation, or you can commit to the Department of Youth Services, or you can file the complaint.
And that's based entirely on the use of the word hearing, then?
No.
What's it based on, then?
No.
I don't understand.
It's based upon an adjudication, Your Honor.
But there's no in my scenario, the judge has not made an adjudication.
And that's why
whether a judge may not make an adjudication and may make a continuance without a finding. The key language is without a finding.
But the key point I would suggest, Your Honor, is that you can only read paragraph 2 after reading paragraph 1, and the way to get to an adjudication is through a trial, or a plea, of course. The way to continuation without a finding is only through a plea or submission.
But that's based on the adult, on the cases regarding adults.
It's aided largely by reliance upon the adult cases. I agree with that, Your Honor. There are no cases that interpret the statute as I'm suggesting.
But you're not denying that the legislature by statute may provide that option.
I'm not denying that, Your Honor, no.
So the issue is whether this statute does indeed provide that.
Yes, that's exactly the issue, Your Honor. And I would submit that because the legislature used the word hearing and not trial, that made specific provisions for pleas, whereas in other provisions of 119, the words trial by jury and trial are specifically used. In fact, a juvenile court judge sitting at a trial is empowered with the same rights, powers rather, as a superior court judge, and superior court being reserved for adult cases. And so I would say that when a trial is the use of the word trial is specifically and unambiguously included in the statute, that means trial. When the word hearing is used, I don't believe that regards pleas and trials. That regards less submissions or pleas. And I understand that this is a tough question because, and I am asking the court to make take a very close reading of the statute. But aside from that, the bigger picture is simply this: the Commonwealth is mindful of Section 53 that says we must treat children, strike that, juvenile offenders as children. We respect that, Your Honor. We respect that because the final sentence of the statute says we treat juvenile offenders as children, not as criminals. That's the entire reason for having this juvenile proceedings, delinquent, not delinquent, as opposed to guilty, not guilty. They're not convicted, they're delinquent, et cetera. But more importantly, this court has found time and again that when an adult defendant, I would say a juvenile offender, challenges the Commonwealth's evidence before a jury, that they've made a choice. They want to go all or nothing. And I don't think that is a very large jump to make. What other responsibility can we teach a youthful offender, a juvenile offender, I should say, other than saying you make the choice of going to a jury trial or to a bench trial? The option is delinquent, not delinquent. If they can make that same option and then ask for continuance without a finding, that does not engender any responsibility in the youthful offender. And that would put the Commonwealth to a severe burden, which the court has recognized is not worthy of the well, it's not, poor choice of words. It puts the Commonwealth to a burden, and the juvenile shouldn't be rewarded by putting the Commonwealth to a burden to then ask for the disposition that could have been obtained upon an admission of responsibility.
You know, when you start to talk about the policy implications of Section 53, that tilts towards the juvenile, doesn't it? Because Section 53 also talks about treating the juvenile offenders the way a parent would, doesn't it?
It would, Your Honor.
And it talks about treating them as in need of aid, encouragement, and guidance. And so, and it tells us that as a policy matter, these are not deemed criminal proceedings. So why wouldn't we want the juvenile judges to have that latitude to do what this juvenile judge did after the jury verdict?
Because, well, I have a variety of responses, Your Honor. And with all due respect, I think that the policy of 53 is clear. I think we should not confuse the policy of treating juveniles as children with the fact that their proceedings are deemed not to be criminal. That's not a policy. That's a rule of law. You are not a criminal. I think none of us here can disagree with that. My point is simply this: if you provide the juvenile with the opportunity to put the Commonwealth to its highest burden of proof after a trial, bench or jury waived, jury or jury waived, then you are enabling the juvenile to basically run the court. They'll go to trial time and time again with a jury and say, you know what, I can get a continuation without a finding.
But they don't know that. They don't know that.
I think
you
the
can
lawyers
do it
know that.
if it's a plea, then if the judge is going to do more than the offer, then the juvenile can withdraw. That's beforehand. Afterwards, you take your chances. The judge may, in fact, adjudicate you a delinquent. You don't have a guarantee it's going to be a quaff.
But the point is, that you have the ability of it being a quaff, and I think that is the great incentive to go to trial.
It's just that you can have it as a certainty beforehand, but only a possibility afterwards. I don't see where the big burden.
I don't think it should be a possibility, Your Honor.
Well, but that's then a policy decision that you're urging in light of the statute as a whole.
Well, no. When we talk about policy versus the law, I think the law is very clear. We treat juveniles as children, not as criminals. We adjudicate them. We don't convict them. That's understood. But I think in terms of actually engendering values in a child, to tell them you can go in front of a judge, have the plea rejected.
So you want us to basically be teaching children a lesson by doing it one way rather than another? I
don't think it's teaching them a lesson. I think it's treating all defendants or juveniles equally. And I agree with Judge Ireland that we do treat juveniles differently than adults. The range of sentencing options, of course, is vastly different in that you're not convicted. You are treated as a child. You may go to DYS. It's not jail. But the point is, I think that for terms of actually following true to the burdens of I don't want to say courtroom management, but the point is that if we do not teach these children that by challenging the Commonwealth's evidence, even after a plea has been rejected, and then still offering continuation without a finding, we are coddling them when they should be treated as juvenile offenders. Now, the fact that they are children, I understand, means that we treat them not like adults. We don't send them to state prison. We don't send them to the House of Correction. We do not permit certain of their convictions to be used for subsequent sentencing purposes. But I do believe that the spirit of the law is certainly such that when a child elects not to admit responsibility, not to show remorse, and simply put the Commonwealth to its burden of proof, that it is an all or nothing proposition. Unless the Court has further questions, I will rest upon my brief. Thank you very much.
Sir. Good morning. If it pleases the Court, Craig Bartolomei on behalf of the juvenile. With me is Attorney Amy Winston.
Mr. Bartolomei, do you call what the jury did here, is that adjudicating, an adjudication of delinquency?
Yes, I would say it is an adjudication of a delinquency.
So you're saying the judge then has to vacate that finding?
I believe what the judge did in this case is the judge enters on the docket that the child was adjudicated delinquent and then determines that in lieu thereof, she will continue the matter without a finding.
But couldn't you
There is
read
I'm sorry, but there is a finding.
Yes.
I agree, but as the statute states, very specifically, if the allegation is proved beyond a reasonable doubt, the child may be adjudged a delinquent.
But
in lieu thereof.
But doesn't that, I mean, to me, doesn't the language of the first paragraph suggest that if the judge, I mean, this is where Justice Gants started, I think, if it's a jury-waived case and the judge finds the allegations proved beyond a reasonable doubt, the judge can say, I'm not going to adjudicate this child as a delinquent. I'm going to continue without a finding. But once the jury does that, doesn't the second paragraph kick in?
I would respectfully say that that's not what the first paragraph says. The first paragraph says, at a hearing of a complaint, the court will hear evidence and then there will be a determination. It doesn't say the judge will. And I respectfully submit, in this case, I know as an attorney practicing before any court, I often think of the court and the judge as the same. But Section 52 of 119 specifically defines the court as a department of the juvenile system.
Well, then why in this case could not the judge have instructed the jury, you can find him not guilty or not, whatever it is, not responsible, not delinquent, or you can find him delinquent, or you can continue the case without a finding? Why not let the jury make that decision?
I don't believe that a continuation without a finding is ever the responsibility of the jury.
All right.
So the jury's job is one or the other, delinquent or not. And then, given the statute, I believe it gives the judge the option.
But under the first paragraph, would you agree that they are mutually exclusive alternatives? That is, the juvenile can either be adjudged a delinquent child or, in lieu thereof, the court can do a quaff, right?
Yeah, yes, the court can do one or the other. But
Okay.
I believe...
But, so,
Yes,
if a jury has decided that indeed this child was adjudged a delinquent child, doesn't that end the choosing right there?
No, I don't believe the statute reads that way. I believe if the child has been adjudged delinquent by whomever, a jury or a judge, then in lieu thereof, the court can continue it without a finding. That would be the decision of the judge, not the jury.
Right, but
So I don't read the statute that way.
The problem with that is that the second paragraph, which speaks of adjudication, does not include a quaff among the options.
My reading of the entire statute is basically that the first paragraph sets up how a child is adjudged delinquent beyond a reasonable doubt, in lieu thereof a quaff. So basically it's setting up how the child is found delinquent. If he's not, or if he is, the judge can then continue the matter. If not, then the judge did not continue it, therefore he is delinquent. Then paragraph 2 discusses what happens after he's delinquent. So I think paragraph 1 sets up the process. Paragraph 2 says, okay, the continuation without a finding was not given in lieu thereof. You have paragraph 2, which says this is what can be done. He's been found adjudged delinquent. And then paragraph 3 would be the youthful offender, which is not at issue here.
I don't want to beat a dead horse here, but I don't understand. Can a judge under the first paragraph find the child delinquent and then say, well, it's a quaff? Can the judge do both?
So you're asking at a bench trial?
At a bench trial.
I would say yes, absolutely.
So the judge could make an adjudication of delinquency.
Yes.
And say, I'm going to continue it without a finding.
Yes, I would venture to say that's exactly what this statute allows, as well as with the jury trial. I also think it's important to note that, given a case like Powell, the judge almost has to find them delinquent, enter it on the docket, and then ask if the child, which in most cases...
What is the finding in continued without a finding that's made?
I'm sorry, I'm not...
What is the finding referred to in continued without a finding?
It's that...
Guilt.
It's basically that there's sufficient evidence to find the child delinquent. I'm not sure if I'm...
Without making that finding?
Well, you're making the finding, then you're continuing it and basically allowing the juvenile or any...
But you're not adjudicating the child a delinquent, is that correct?
That is correct. You are not adjudicating. If he violates the continuation without a finding, then he could be adjudicated a delinquent child. because he has admitted that there were sufficient facts to do so.
If you agree, as I think you did, that what the jury did was adjudicate this child a delinquent, correct?
Yes, that's what happened in this
So
case.
back to Justice Gants, do you have to vacate that in order to get to the qua?
No, I don't believe so. I believe you enter it, and then in lieu thereof, you grant the child continuation without a finding. I know in this case the judge certainly followed that pattern. I know that pattern is the way it's listed in Chief Justice Ireland's juvenile law treatise. You enter
well,
the
that resolves it. I guess.
Yeah. Well, if we don't agree with you, does that mean that the interpretation of the first paragraph is what Mr. Pieropan said, which is that what the language is referring to is a guilty plea and not a trial at all?
I think that would be the only way you could not agree with me. I believe you either agree with that it's a jury trial or a bench trial, or you have to assume it's a plea. I would venture to state, though, that the language doesn't state that.
Well, why couldn't you find a bench trial under this?
Well,
because then you're the judge, and you say the evidence is sufficient, but I'm not adjudicating the child a delinquent. I'm going to do the quaff instead.
I don't think the language differentiates between a judge or a jury, and therefore it has to include both.
But the first paragraph distinguishes between proof beyond a reasonable doubt and adjudication, because if there's proof beyond a reasonable doubt in paragraph 1, the judge has two choices. He can adjudge the child delinquent, or he can do a quaff.
In lieu thereof, yes.
So going back, I guess, to a question Justice Spina asked, why could a judge not to a jury say, I'm simply going to ask you whether or not the allegations are proved beyond a reasonable doubt, and I will reserve for myself then whether or not I will adjudicate the child delinquent or whether I will do a quaff, and rely upon the language of the first paragraph, which makes that distinction.
I would venture to say that's the same thing as offering them to a not delinquent or a delinquent, because that's the option for a judge, for the jury, I'm sorry. They determine the facts. They decide the child did it or there's proof beyond a reasonable doubt. And then, if they do, we get back to it. I think the key here is that what you're asking is similar to a plea without the jury, and proof beyond a reasonable doubt is not used there. That's not the language in a plea. So I think the jury has to make the determination of delinquent or not delinquent before a judge can then decide to continue it in lieu thereof. I would also state, just with some of the other comments that the Commonwealth made relating to the term hearing being used elsewhere in the statute, the 119 juvenile statutes, they refer to jury sessions, which is basically Section 56. 56 refers to hearings for adjournments, does not include any language about trials in that. Where they do discuss trials is in Sections A through H, which is in essence really setting up the jury session. It's not so much differentiating. A judge may sit at a trial. It's setting up how a juvenile would be tried. Therefore, the use of the term hearing in the first paragraph of 56 has to include trials, otherwise there'd be no ability to continue a trial. I think what this court has to keep in mind is certainly, as the ADA discussed and you asked, the purpose of the juvenile system is different. It is not the same as an adult system. It is to be liberally construed under Section 53, so we're liberally construing Section 58. It's for the aid and encouragement of a juvenile. In this case, this judge determined that a continuation without a finding after the trial was in the juvenile's best interest, his best interest going forward, which could mean not having a record, which I think sometimes the records are able to be used against them. It's also to help him better himself. There are many places where a delinquency finding affects a juvenile. I think the statute is set up in such a way that it's supposed to treat the child differently. As Chief Justice Ireland said, for the most part, as a parent would. And therefore, giving the judges this option, which I believe the statute very specifically does, follows the purpose and the spirit of the juvenile system, which is putting aside youthful offenders to treat delinquent children or children charged with delinquent acts differently than adults. I think that is very important to keep in mind. I would also just state some of the other arguments the Commonwealth makes as far as the rules of criminal procedure. The general laws take precedent per Rule 1B in the juvenile matters. The Rule 1B specifically states, as consistent with the general laws, once again. So I think the Commonwealth's reliance on the adult cases, the rules of criminal procedure, it all comes back to the one determination of whether hearing of a complaint is a trial or not. I would suggest to this court that it is a trial, both jury and bench. I don't believe that it means anything other than that. I don't think the language of 58, when you include everything else, could mean anything other than that. If there are no further questions, I will rest on my brief.
Thank you, sir.
Thank you, Your Honors.